Well, I think we're gonna about ready to start. All right, hello everyone. Welcome to our webinar on justice and accountability efforts in Chile after Pinochet. My name is Timothy Franklin, and I'm the co-chair of the International Criminal Law Committee of the American Bar Association International Law Section. Practitioners and scholars of international law are likely aware of the Pinochet extradition case, particularly its role in the development of universal jurisdiction and head of state immunity. But the specific events of the case and the developments in Chile following Pinochet's death may be less familiar. Our guest speaker today, Javier Andres Contreras Oliveras, is a Chilean lawyer with extensive professional experience in human rights, international law, criminal law, and public policies. For 10 years, Javier disputed high technical complexity accountability cases about gross violations of human rights perpetrated by the dictatorship of Augusto Pinochet between 1973 and 1990, with a high rate of convictions. And since April of 2022, Javier has been the legal advisor of the Unit of Public Policies, Division of Promotion, Undersecretariat of Human Rights of Chile. He has a lot to talk about, and I know a lot of you already have questions for him, and more will come. So let's get right to it. Javier, go ahead.
Thank you very much, Tim, and good morning, everyone. In Santiago, we have the same time as in New York. So I will share with you my screen. I have a PowerPoint with my presentation. So please tell me that you're watching my screen. Okay. So this is the main subject of my presentation, justice and accountability efforts in Chile after Pinochet. But to talk about that subject, we must start with a bit of history. Everything started when Salvador Allende became president on September 4th, 1970. He was the first Marxist socialist president elected democratically. And the government coalition that supported Allende was the Popular Unity, Unidad Popular, of left-wing political parties. But since Allende assumed as president, his government wasn't easy. He must receive and have a lot of problems with the far-right political parties. And some of the troubles that Allende must confront was based on a strong expropriation of enterprises in key segments of economy, like copper and agriculture. The private enterprises and the right-wing political parties were very upset with him. And there was a heavy economic problems. Allende tried to use legal cracks avoided National Congress to bring his policies fulfilled. And some of the problems related to that was a high external debt, high inflation, public deficit, black markets. So the situation was very chaotic, and that brought a political polarization with a lot of violence. And the armed forces that was very respectful of the Constitution began to conspirate. And what happened then? On September 11th, 1973, the military personnel. In this case, there was a military joint that were the members were Augusto Pinochet, the commander-in-chief of the army, Gustavo Lee, the commander-in-chief of the Air Force, Toribio Merino, who was a vice admiral. He nominated himself as admiral, and by that he was the commander-in-chief of the Navy, and the General Cesar Mendoza, who was appointed himself as director of the Carabineros, the military police. They started this coup d'etat on September 11th, 1973. This coup d'etat was supported by the Chilean right wing and the private enterprises, and by the CIA at that time. We must remember that this happened during the Cold War. So there was, for Richard Nixon and Henry Kissinger, they were very afraid that Chile could be a second Cuba. And so the CIA supported all the military coups in Latin America, and Chile was not the exception. And this coup d'etat was heavily influenced by the national security doctrine of the School of the Americas in Panama and the French doctrine of colonization of Algeria. And in that day, President Salvador Allende committed suicide. And just like that, this terrible dictatorship started and finished in 1990 on March 10th. There was an authoritarian, anti-Marxist, and military-civilian dictatorship. All the democratic institutions were eliminated. The National Congress was shut down, the Constitutional Court was shut down, political parties were banned, and the electoral system was shut down. So there was no democracy, just like that. And also, Chile suffered radical transformation, especially in the economy. The socialist economic system just finished on September 11th, 1973, and the military joint has this idea to restart the economy, and they were heavily influenced by the School of Chicago, of the University of Chicago, and so the actual economic system that is running Chile is very capitalist and neoliberal. In a social aspect, the business groups control the whole economy, and that brings a high rate of social inequality until today. If you remember in the news on October 2019, here in Chile, we suffered a social uprising, heavy protest in all the Chilean cities, and that was very related to the high rate of social inequality. There are a lot of people that live under the poor rates, and few people that are very rich. So the middle class, it practically didn't exist. And also cultural changes, the freedom of expression, for example, was banned. And in 1981, and this is very important, the military joint written a new constitution. And that constitution is the constitution that is still ruling Chile until today. And we have two attempts to start a constitutional convention. Both projects failed. And so Pinochet constitution is still ruling today. Also, something very important, justice didn't exist. If there was few brave judges that filed criminal actions in this inquisitorial system. And they started investigations, but a few weeks later, the military jurisdiction took control over these criminal cases and closed the files. All the habeas corpus actions were rejected by the Supreme Court. So there was no justice for the victims and their relatives. And also was a main characteristic of the dictatorship, gross human rights violations that became crimes against humanity. The majority of those crimes were perpetrated by the two political police of the dictatorship, the DINA, that means the National Intelligence Direction, and the CNI, the National Information Center. There was policies just like the Stasi or the KGB, people that were trained by the military personnel to kidnap left-wing supporters, torture them, kill them, and in a lot of cases make them disappear. And also the intelligence units of the whole armed forces and the carabineros also perpetrated gross human rights violations during all the dictatorship. Well, and on March 11th, 1990, Chile returned to democracy, and that was the starting point of the transitional justice measures. And I want to talk about 5 things: truth commissions, accountability cases, reparation measures, memory and memorials, and public policies. The first measures were truth commissions. And the first one was the National Commission of Truth and Reconciliation that finishes its job with a report. We called it the Rettig report because of Raúl Rettig, who was the president of this commission. And when the National Commission of Truth and Reconciliation finishes its job, there was, in 1982, a corporation that continued its job, the National Corporation of Reparation and Reconciliation, that upgraded the report that was published by the National Commission of Truth and Reconciliation. And in 2003, there was another Truth Commission, the National Commission of Political Prison and Torture. And the president of the commission was a bishop, Bishop Balic. So the report was called the Balic Report. The difference between those two commissions is that the commission of 1991 was focused on forced disappearance and political or extrajudicial executions. Also, this commission was gained all the information about what happened during the dictatorship, the main reasons about the coup d'etat, the work that was made by the political policies during the dictatorship. But the Commission of 2003 was about survivors of prison and torture. And in 2011, there was an upgrade of the reports of those commissions by the Advisory Commission for the Classification of Forcible Disappearance Victims, Extrajudicial Killings Victims, and Political Prison and Torture Victims. I have the numbers here of the victims. The numbers in red are the upgraded data. So about political prison and torture, the number of victims is 31,856. On extrajudicial execution, the number of victims is 1,747, and about forced disappearance, the victims are 1,469. About accountability cases, well, you have here a picture. Ernesto Moreno Diaz was a victim that was in one of the cases that I disputed at the courts. He was 18 years old, and he was murdered on September 19th, 1973. As I told you before, the criminal process in Chile for the investigation of the gross human rights violations was made under the inquisitorial criminal system. That was the reason of that is the Criminal Proceeding Code of 1906 was the criminal proceeding code that was ruling at the time. So that means that the same judge that filed a criminal action is the same judge that prosecutes, accuses, and convicts. And between 1990 and 1998, the atmosphere during the 90s was almost the full application of the self-amnesty decree law from 1978 related to crimes perpetrated between September 11th, 1973 and March 10th, 1978. If someone filed a criminal complaint against military personnel the courts applied this Amnesty Act, and the case just finished in that moment. There were a few exceptions. Jose Jaulen and Juan Chauquepan case, both of them are victims of forced disappearance. And the kidnapping was treated as an ongoing crime. As the bodies couldn't be found, as the theory was, okay, these persons must be alive, so the kidnapping is still existing. It's still ongoing. So that was the interpretation. Another case was the murder of Orlando Letelier, very important because Orlando Letelier was murdered in Washington, D.C. He was the ambassador, the Chilean ambassador at the United States during the government of Salvador Allende, and he was murdered by the DINA, the first political police of Augusto Pinochet. And by this case were convicted Manuel Contreras and Pedro Espinosa, the boss, the two chiefs, the director and subdirector of this policy. Another case was the beheadeds case, a terrible case from 1985. Three communist supporters were kidnapped and beheaded, and their corpses were thrown in a road outside Santiago. And there was convictions by this case. And on March 10th, 1998, excuse me, Pinochet resigned as commander-in-chief of the Chilean army. But at the following day, Pinochet became senator for life. That means that during the transition, Pinochet still had positions of power. So it was very difficult to bring justice during the 90s. And I want to talk about now, about Pinochet, something related to him that was universal jurisdiction, the Pinochet trial that was filed against him in Spain. There was a criminal complaint against Pinochet that was filed in 1996 in Spain by Chilean victims. And the reason was that those victims couldn't find justice in Chile because of this impunity atmosphere during the 90s. And Spain recognizes the universal jurisdiction in absentia. That means that you don't need to be in Spain to prosecute you. You could be in other part of the world, and a Spanish judge could prosecute you. So Spain recognizes this kind of universal jurisdiction at that time. So the charges that were filed against Pinochet was genocide, torture, and state terrorism. And the first judge was Magistrate García Castellón, and then Baltasar Garzón. Baltasar Garzón was in charge of the Condor Operation case. The Condor Operation was an intelligence operation coordinated by different intelligence units from all the Latin American dictatorships against left-wing supporters. So related to this case, Judge Garzón required Pinochet to bring his testimony, and Pinochet wasn't to bring his testimony, and so Garzón decides to fill an arrest order and to ask the United Kingdom for the extradition of Pinochet. And what happened, Magistrate García Castellón decides to inhibit himself, so Magistrate Baltasar Garzón was in the whole control of the cases related to human rights violations in Argentina and Chile. What the United Kingdom could have done related to universal jurisdiction, it couldn't apply the audidere aut judicare principle. That means or you extradite or you must prosecute the agent. And about the charges against Pinochet, this is something very important. At that time, Spain didn't recognize the crimes against humanity in its legislation. So the UK answered that the double criminality principle couldn't be applied. But there was one exception, torture. And at 1988, Spain, UK, and Chile, the three countries, have been ratified International Covenant Against Torture. So that was the only possibility to apply this principle. And why torture? It couldn't be genocide because the political group is not a group part under the scope of the genocide. We must remember that will be ethnical, national groups, but not political groups are included in the Genocide Convention. And also it couldn't be for state terrorism. So the only exception was torture. And something important, it was that Pinochet couldn't not be benefit from the immunity as former head of state. The principle is established in the Rome Statute of the International Criminal Court. And what was the decision of the judicial branch of the United Kingdom that Pinochet could be extradited to Spain? But the last word was for the UK government. And at that time, the former Prime Minister Jack Straw decided that Pinochet couldn't be extradited due to his health conditions, due to humanitarian reasons. So Pinochet was deported to Chile. And that was how finished this trial against Pinochet under the universal jurisdiction scope. But returning to Chile, what happened? In 1988, the first criminal complaints against Augusto Pinochet were filed on two cases, Conferencia Street and Caravan of Death. The Caravan of Death was a case that I was disputed in the courts. Just to tell about a few things about this case, the Caravan of Death was a massive intelligence operation that was organized by Pinochet himself. And Pinochet, on October 1973, ordered a subordinate general, Sergio Arellano, to fly in a helicopter with a squadron visiting different Chilean cities throughout Chile. And in all the cities that this general visited with his squadron, there were killings, massive killings. Almost 100 people died, were murdered by this operation. And this was one of the important cases in Chile. Another case that was very relevant was the case of Pedro Poblete, a victim of forced disappearance. His case was investigated by the military courts. Obviously, during the dictatorship, the military courts will not convict military personnel, so the case was closed. But the Supreme Court said, okay, this investigation must be reopened because that decision of the military court was against the Geneva Conventions. The statement was those crimes are crimes of war. So as crimes of war, and Chile signed the Geneva Conventions, so it couldn't be, those Geneva Conventions should be applied. The first prosecution against Augusto Pinochet in the Caravan of Death case, the case that was under my responsibility. And in that time, Pinochet was prosecuted, but a few months later, he became mentally ill. That wasn't true, but the Supreme Court accepted that theory. And so this case couldn't be followed against Pinochet. There was a change of integration of the second branch of the Supreme Court of Justice. This was very important because during the 90s, the Supreme Court was supporting Pinochet. Also, there was a decision that could be magistrates with exclusive dedication for human rights violations cases. Another important case was the case of Miguel Sandoval. He was victim of an aggravated kidnap. And that was equivalent to the internationally defined crime of forced disappearance. And the case of Amenacida Arellano versus Chile of the Inter-American Court of Human Rights was very important. This case followed the same pattern that was established by the Inter-American Court of Human Rights in the cases of La Cantuda and Barrio Salto against Peru, due to the amnesty that favored Alberto Fujimori. So the statement of the Inter-American Court of Human Rights was self-amnesty and amnesty acts couldn't be applied in cases related to human rights violations. And in December 10th, 2006, Pinochet dies. And what happened after Pinochet's death? Well, all those cases related to human rights violations continued. Just to name a few, the case of Rudy Cárcamo, she was victim of forced disappearance, and her case was treated as a crime against humanity, the kidnap. The case of Bárbara Uribe, for the first time, a woman that was victim of rape and sexual violence. This case was, the statement was, sexual violence must be understood as a separated crime of torture, because the previous statement of the court was sexual violence is under the scope of torture. And in the Chilean dictatorship was very chauvinistic. There was a lot of women that were victims of sexual violence. Just to tell you something that was something very terrible. Here in Santiago was a detention center called the Discotheque, or the sexy strip, Venda Sexy, because they put that strip in just to cover your eyes, and all the violence was related to sexual violence. All the women were raped, and it was so terrible that the military personnel had a German shepherd dog that was trained to rape women. Other cases, Victor Jara, our famous Chilean singer in the United States, the civil case that was against Pedro Barrientos, one of the military personnel that went to live to the United States. He has been extradited a few months ago to Chile. The Paine case, it has a lot of episodes. One of these episodes was the Cuyipemo episode. In that case, was the first case when a civilian was convicted. And just to tell you another cases, the case of Federico Alvarez, the first time that medics were convicted, medics that would perpetrated torture and other crimes. And something interesting was the case of Jorge Oyarzún and Juan Escobar about the La Tercera newspaper. In this case was very interesting because La Tercera newspaper has to reinterpret a news that was published during the dictatorship, telling that Jorge Oyarzún and Juan Escobar were terrorists. And the Supreme Court of Chile said, okay, that was a lie, so this newspaper must to tell the truth. And in that picture that was taken by me, as all the pictures that you're watching in this presentation, those guys seated in the picture, they're reading a newspaper, La Segunda, with the following quote: "Exterminated like rats." That was one of the most embarrassing first pages of the newspaper in Chilean history. And those guys seated over there are wearing hats with the shape of a mouse. And that was one of the greatest lies during the dictatorship that was published in a newspaper. And just to finish in this point, the Quran of Death case, the episode La Serena, that was one of the major cases under my responsibility. It was very hard to dispute this case at the courts because of the person of Juan Emilio Teire. Who was Juan Emilio Teire? He was commander-in-chief of the Chilean army after Pinochet. There was another commander-in-chief between Pinochet and Teire, but Teire was the second one after Pinochet. And he was protected by the whole political society in Chile. So he has a lot of power. It was very, very difficult to prosecute him, but we achieved our goal. and on December 2023, he was convicted. He didn't receive a conviction of jail, but for a person who has a tremendous amount of power, it was very important to convict him. Reparation measures. Just to name a few examples, we have two acts. Act number 19,123 and 19,980 are both acts of reparation. And those acts establishes reparation pensions, scholarships for the victims' relatives, a program for mental health, the Reparation Integral Assistance on Health and Human Rights Program, and conscription waiver. You must understand that a relative of a victim that was killed by military personnel couldn't follow the conscription. So there was a measure for the victims' relatives, a kind of reparation for all the suffering that the victims and their relatives suffered during all these years. Memory and memorials. I have two pictures here. The one on the left is the Museum of Memory and Human Rights. It's a very beautiful place that tells you all the history of the dictatorship and the gross human rights violation. It's a space for reflection, for thinking, and you could see a lot of things related to the dictatorship. And on the right is a memorial that's very special for me because it's from the city that I was born in, the city of Calama in northern of Chile. And that place was a former open mass grave related to the Caravan of Death case. In the city of Calama on October 1973, 26 persons were kidnapped from the Calama prison, and they were transported to the desert and tortured, killed, and made them disappear. And this was the grave when the victims were buried. What happened with this case was that a few years after this murder, this mass murder, there was a direct order of Pinochet to open mass graves in Chile, alongside Chile. And the military personnel took the corpses and threw the bodies on the Pacific Ocean. That was an operation called the retirement of televisions. The televisions were the victims' corpses. So this is a memorial that was very beautiful. You could see some pillars that represents the 26 victims that are in a hug all together. And some public policies that are very interesting. We have the National Action Plan on Human Rights. We are now in our second version from 2022 to 2025. And in one chapter of this National Action Plan is related to truth, justice, and memory. And that means that different ministers, undersecretariats, and public services fulfill measures about different topics. Could be LGBTIQ, children, elder people, and also truth, and memory, and justice. For just to name an example, the National Stadium here in Santiago was a former detention center. A lot of people died being tortured there. And now there are roots of memory that are in charge of the Ministry of Sports. they created those routes of memory. So every person that entered to the National Stadium could walk through this route and to know what happened in the National Stadium. And last year, President Gabriel Boric signed the National Action Plan for the Search of Forced Disappearance Victims. This was a major turning point. This is a public policy that should have been applied years ago. And something I want to tell you in the next sheet is that one of the biggest problem, I think that the greatest problem with the accountability cases is the passing of time, because all the military personnel that was in charge of the garrisons of the military units in 1973, they are all dead. All the generals, all the colonels, the lieutenant colonels, vice admirals, rear admirals, all of them are dead. And they were the main responsibles of the perpetration of those crimes. So when these people died, a lot of information is lost. And the military personnel knows where are the victims of the forced disappearance. Maybe not the current military personnel, because it has passed a lot of years. But the former military personnel, at the time, they knew exactly what happened with those victims. So this is the last effort, I think, to start a public policy that could try to establish what happened with those victims, alongside with the accountability cases that establish a judicial truth. This is another measure to try to obtain different sources of information about what happened with the victims, to search for the bodies, and to bring the possibility to the victims' relatives to close this terrible episode of their lives. And some current problems with this sheet, I'm finishing my presentation. Biological impunity. That means what I was telling you before. All the military personnel that was in charge of the garrisons and military units are all dead or became mentally ill. Second one, the slow processing of the cases. Just to take the example of the warrant of death, the criminal complaint filed against Pinochet was in 1998, and the last episode of that case finished on December 2023. A lot of years. And during the processing of that case, a lot of military personnel died. All the colonels, all the generals were dead. So we only have non-commissioned officers or lieutenants or captains at the time. That also has responsibility, but they are not the people who take the main decisions about what happened with the victims. Silence agreements, that was a big trouble here in Chile. All the military personnel that perpetrated these terrible crimes, those international crimes or core crimes under international law, have this agreement to not talk about what happened. And those guys fulfill this agreement or this oath until their deaths. Low conviction rates, as I told you about the case of Juan Emilio Cheire, he was convicted as an accomplice of law, as an accomplice of crime, excuse me, but he didn't put a foot in the jail. He has a major responsibility, but due to the low conviction rate, he must not put a foot in jail. Another problem is the 50 years of secrecy established for the documents presented by the victims of political prison and torture to the National Commission of Political Prison and Torture. This 50 years of secrecy was established by the act that created this National Truth Commission. And The problem was that all the victims, survivor victims of torture and political prison, couldn't complain against the military personnel because of this rule of secrecy. My interpretation of this is to bring impunity to the military personnel. President Ricardo Lagos said about this 50 years of secrecy, it was to protect the victims because all the testimonies were so terrible. But the victims had the right to fulfill a criminal complaint against the persons that tortured them. And I think, as I told you, that this measure brings impunity to the military personnel. We have a problem of convicted fugitives. That happens because when the Supreme Court dictates the last sentence, in that time when the sentence has to go down to the base court or to the base judge, in that period of time, a lot of military personnel became fugitives until today. And when one person that was convicted in the caravan of death case, that was convicted to, if I remember well, 15 years of prison, he's not a fugitive. And the police couldn't find him until today. The health prescription is a measure established by the criminal code, and that means that if a person that was prosecuted or convicted appears to the court or presents at the court after 15 years, if I remember well, that means that he could be benefit with a reduction of the conviction. And also we have problems about negationism by far right-wing politicians. And my interpretation is that the Chilean society is very polarized until today about what happened with the dictatorship. And that means that the challenge is to continue bringing or designing and implementing public policies about truth, justice, and memory. And I want to finish with this quote of George Santayana. This is a picture that I took on Auschwitz on March this year. I think it applies for every kind of human rights violations. Those who do not remember the past are condemned to repeat it. And that's the most important thing about the transition of justice, to strengthen the democratic institutions, to keep the memory of the victims, with the main objective that those terrible crimes could not happen again in every part of this planet. And that's all, and thank you very much for your time. I hope that you enjoyed my presentation, and I'm open to answer any questions that you have. Thank you very much.
Thank you. Thanks very much. That was an incredible presentation. We have a number of questions, and please, if anyone would like to post a question now, please do so in the chat, and we'll try to get to as many as we can. I'm going to just do these in no particular order. Some of them I'm sure you've addressed already, but because these were asked prior to the presentation. In the National Action Plan, what are the ongoing challenges in documenting the human rights abuses that were not covered by the two previous Truth and Reconciliation Commissions?
Well, thanks for the question. I think the major challenge is to find different sources of information. Because just to give you an example, in the ground of death case, I have testimonies of different people, military personnel of the garrisons, testimonies of eyewitnesses that were tortured with the victims, and some reports that were published in the newspapers at the time. But there's a lot of information in public libraries. In one of the public libraries here in Chile, there's a huge archive of decrees, acts of the intelligence policies at the time. And I just went one day to those places, to the public library and to this National Archive, and I found a lot of information that would very important for the case to prosecute Juan Emilio Teide. So it was a mine of gold that I found in that case. So related to the National Action Plan, I think there's a lot of information in different places that could tell us what happened with the victims of forced disappearance. Maybe could be names of another military personnel that were involved in the commission of those crimes, maybe eyewitnesses. And this is a major challenge. And as I told you before, the great problem, the big problem is the passing of time. Because if we could find a name, we must look out if that person is alive. Also, if there is military personnel that are dead, also we have eyewitnesses that are dead. People who were elder people at the time are not living until these days. So there's some major information sources that are lost when people died. But I think that's a major challenge to look out for another sources of information in different places, and to ask again to the actual military personnel to look again in the archives if there is new information about the fate of the victims of forced disappearance.
The Valak report, the premise of the silence was victim privacy, right? I mean, so that, but is that, there is some legitimacy to that, or I mean, or at least currently now there are legal, I mean, GDPR alone, I mean, just protection issues that would come into play if there were, if this was, if NGOs were to be participating in this. I'm just thinking about how would this be, how would you handle that side of things? I mean, are those, or even if there were individuals that wanted to have their families, information kept secret, is that being addressed, or is this, I mean?
It was a major problem because during the passing of time, some of the victims, the survivors, want to file criminal actions against their torturers. And it couldn't do that because of this rule of the 50 years of secrecy. But there was a lot of victims asking to bring back the information that they presented years before for this Truth Commission, to the Valak Commission. And in some cases, those files were opened and the victims could present criminal complaints against the torturers. But the problem was that during a lot of years, all these victims were discriminated, because why relatives of victims of forced disappearance or extrajudicial killings could file criminal actions, but victims who were survivors of torture and political prison could not file those criminal complaints. And this discrimination was widespread in the following statement. On my previous job, I'm working under the Secretariat of Human Rights. There's a unit that, in representation of the state, fill these criminal complaints, but it has it only could fill criminal complaints related to victims of forced disappearance or extrajudicial killings, not for political prison and torture survivors. So that's another challenge, because there's a lot of people who were victims of torture that couldn't obtain the records and the documents that they presented years ago to the Truth Commission.
Yeah.
And I don't remember if there are NGOs that are supporting them in this moment. I can remember. But there are a lot of NGOs like Amnesty International that said in public statements that the rule of 50 years of secrecy was wrong. It wasn't a good measure. But those victims are actually alone. I knew a lot of them that have to find a lawyer that could support him and to file a criminal complaint against the torturers. But it's a responsibility of the state to bring justice for those victims.
Sure. On that note, we have a question that what role can civil society play in shaping and monitoring the adaptation and implementation of these kinds of commissions in their own countries? For example, getting around the limitations of these the 50-year silence and how can we learn from this, just in terms of advocacy?
Civil society must play a major role. During the last years of the dictatorship, civil society bring a lot of pressure to the military junta to finish the dictatorship. And during the 90s, the civil society bring a lot of pressure to the judicial branch to fill criminal complaints against the perpetrators. But the problem is that the force that have those groups of the civil society, especially women that suffer the loss of their husbands, their brothers, their sons, lost that power. They are now old elder people. It didn't have the same force during the 90s. And I think there must be a new maybe groups of civil society that could take this flag and to bring pressure again against the judicial branch, against the government or the state in general, to bring justice, especially for the National Action Plan for the Search of Forced Disappearance Victims. In that National Action Plan, one of the main pillars is the participation of the civil society, especially the victims' relatives. But I think, maybe I could be wrong, but this is my interpretation, about what happened on October 2019 with the massive protests of the social uprising. I think the people are now very tired of protests. And the last year, 2023, we commemorate the 50 years of the military strike. And I thought, okay, this is a good year that we could bring a new public policies, that the civil society could start to speak again with the same force as during the 90s. But everything was very quiet. And it's sad because I think we lost a great opportunity to do more things related to to the accountability cases, to this national action plan, and other matters.
You think that the constitutional reform, that the lack of getting support for that was, I mean, that was indicative of something? I mean, you think that's a starting point?
Yeah, it was terrible. I mean, and the first attempt to write a new constitution, all the people were very, very, very enthusiastic. The 80% of the Chilean population was agreed that a new constitution, that we must have a new constitution. But the bill was so bad, it was rejected massively. And then another constitutional commission was created with people appointed by political parties and that are not supported by the people. I mean, from the left to the right, no one in Chile likes the political parties, no one. And obviously this second attempt was a failure again. So I think it will pass, I don't know, another 50 years to have a new opportunity to have a new constitution. We lost the opportunity. I mean, it was
the opportunity, but
sad.
I mean, I guess you guys know,
yeah.
If you know one thing by now, it's that just changing out something for something else is not necessarily the best thing, right? Because I mean,
I mean, you know, the first bill of the new constitution, okay, it was bad, but everything is better than the Pinochet constitution, in my humble opinion.
Yeah.
But it was a very big constitution, almost 300 articles, and you couldn't ask to the common people to read 300 articles in a very technical language without the support of public campaigns about how important it is to have a new constitution. I mean, a new constitution is not the solution of the problems, but it's the starting point.
Sure.
For new changes, and we lost the opportunity.
So there's look at it as a learning experience for the next one.
I think
right.
Yeah, I think it's a very good case study of how
not to reform your constitution. That's and not just for Chile, but for other countries that want to do this.
Yeah, and also about this process, there was a lot of fake news, a lot of fake news bring by the far right supporters. There was a lot of lies in the media, in the social platforms, and people became scared with things very, very surrealistic. Like, you will lose your property if you sign for this new constitution, and that wasn't true.
Easier to consume the news than the actual constitution text, right? So it's, sounds a little familiar with eerily familiar with other things. Well, okay. Well, I'm afraid that's all the time we have today. I wish we could go longer. But let's continue this conversation somewhere else sometime very soon. If that's, I'd be honored to do that. It's been an absolute pleasure having you. And it's been incredibly educational and fascinating. Thank you very much. Everyone, our next program is going to take place on April 26th at 11 a.m. Eastern Time. The topic will be the launch of the independent inquiry into breaches of the Genocide Convention in Darfur, Sudan. So we will hopefully all see you there then. Thank you very much. And until we all meet again, be well, and we'll see you next time. Thank you. Thanks, everyone.
Thank you, Tim. And thank everyone for this excellent opportunity. It was my pleasure.
Thanks very much. Take care.